afternoon. Welcome to the Tom Lantos Human Rights Commission's hearing on advancing human rights through international prison reform. It's an issue that is very close to my heart. I offer a warm welcome to all of our witnesses and want to also acknowledge my strong bond with one of our witness organizations, Prison Fellowship. In fact, I'm a founding member of Prison Fellowship's Faith and Justice Fellowship, which was established in 2016 to bring together a group of policymakers from various faith traditions and political parties united in a desire to promote restorative values in the criminal justice system. I know Craig DeRoche and we'll talk about the inspirational story of Prison Fellowship and its founder, Chuck Colson. Chuck had a huge impact on my life and on my family, was honestly one of my mentors from a distance, but also had a chance to spend quite a bit of time in 1 year. I was part of a Centurion program that they had of training people who are involved mainly in state and local government to be involved in important issues of justice and impact for good. And through his impact on my life and also seeing how he turned something that was dark and difficult in his own life of having to serve in prison, but also recognizing the problems that prison systems have, to a commitment to better our prison systems here, but also around the world. And am convinced that because of his work and Prison Fellowship, literally hundreds of thousands, if not millions, of prisoners have been impacted for good. And reminded of Chuck Colson often, our youngest son. We've got 4 kids, my wife and I, but our youngest son we named Colson after Chuck Colson, and we call him Cole. But when he's in trouble, he's Colson. But still think about Chuck often and miss him when we lost him 5-6 years ago now. But anyhow, grateful for him, but also for Prison Fellowship and the work that continues. My concern for prisoners and about their need to improve prison conditions comes mainly from my faith, but also under that recognition that every single person is of value. And I think everybody watching and hearing this hearing, whether they're driven by faith or not, would agree that every life has intrinsic value and dignity, and that every prisoner has the potential to redeem himself or herself. Unfortunately, too many prisons are run in a way that crushes the human dignity. This is true around the world, and yes, too oftentimes even here in America. This is a human rights commission, and I believe that anybody who knows the facts about prison conditions worldwide will have to agree that terrible violations of human rights are inflicted on millions of prisoners. It's not a contradiction to recognize that although some people deserve to be imprisoned, while they are in prison, their treatment should meet basic human rights standards. Nelson Mandela, himself a prisoner for nearly 30 years, famously said, and I quote, "No one truly knows a nation until one has been inside its jails. A nation should not be judged by how it treats its highest citizens, but its lowest ones." And I end that quote. When we look inside jails around the world, what will we find? Too often we find torture. But even where explicit torture is not used, there are conditions amounting to torture. Prisons where horrific violence is condoned while wardens turn a blind eye. Terrible overcrowding and lack of health services, which combined seem designed to spread the worst diseases, HIV, tuberculosis, hepatitis, among others. Too many prisons and prisoners lack basic clothing, food, clean water, and even sufficient light to see. The impact of these conditions is often disproportionate on vulnerable populations, including youth and women. And this mistreatment has had an impact beyond the prisoners themselves. It has an impact that is shared by the innocent families of prisoners who live on the outside or appallingly are sometimes forced to move into the prison themselves. We find the impact on communities where prisoners who have been denied any meaningful chance to improve themselves will be returned to a society ripe for recidivism. During this hearing, we'll discuss what is wrong with prisons worldwide and how the reality of prison life often fails to meet these minimum standards. But I believe we can also learn about real solutions that are being tried and succeeding, programs and ideas that transcend partisan boundaries and which can give us hope that meaningful international prison reform is possible. And with that reform comes a positive impact on individuals, their families, and their communities all over the world. There are internationally accepted standard minimum rules for the treatment of prisoners, known fittingly as the Mandela Rules. Philip Meissner is the prison reform focal point in the UN Office of Drug and Crime in Vienna, Austria. He's come to Washington to discuss these rules. He's going to be our first witness, but I'm going to first recognize my co-chairman and colleague, Jim McGovern, who it's my honor to serve with.
Well, thank you very much, and good afternoon, everybody, and I join my colleague and co-chair, Randy Hultgren, in welcoming all of you here today to our hearing on advancing human rights through international prison reform. I especially want to thank our witnesses for their presence and for sharing their expertise and their recommendations with us on this important issue. I'm going to apologize in advance. As I was mentioning to my colleague, we just were notified this morning that the Rules Committee will meet at 3 on the continuing resolution, which, for those of you who aren't following this, means whether we keep the government open or not. So, you know, this is important, but I gotta, you know, I might have to do that brief for a little bit. But as we'll hear this afternoon, more than 10 million people around the world are imprisoned. In most regions, the number of people in prison has grown since 2000, often substantially. In the Americas by 108%, excluding the U.S., and 75% in Southeastern Asia and the Middle East. Women make up a relatively small but growing share of the prison population. Many prisoners face dire conditions, overcrowding, violence, both inter-prisoner and between staff and prisoners, torture, denial of health care, unhealthy and insufficient food, forced labor. Privacy is scarce, to put it mildly. Children, women, the disabled, and LGBTQ people are especially vulnerable to discrimination and mistreatment, including sexual violence. Many imprisoned people are in pre-trial detention, meaning they suffer these conditions without yet having been convicted of anything. As we hear the bad news about prison conditions around the world today, it is worth reminding ourselves why societies imprison people in the first place. What are we trying to accomplish when we put people in jail? There is pretty wide agreement that we imprison people for 2 reasons: to deter crime and to reduce recidivism, to make it less likely that people will continue to commit crimes. But if people come out of the prison system broken and embittered, with their families destroyed and unprepared to work and stigmatized to boot, it is unlikely that societies will achieve these goals. Not much good comes from breaking people's souls. The good news is that there is widespread international consensus on the standards that should guide the treatment of prisoners and protect vulnerable populations of prisoners like women and children. As my colleague mentioned, the Mandela Rules, named for Nelson Mandela and adopted by unanimous consent by the UN General Assembly in 2015, embody that consensus. Complementary rules like the Bangkok Rules for women and the Beijing Rules for youth provide guidance for vulnerable populations. These rules begin by recognizing the fundamental human rights of every person without distinction of any kind. A prisoner is still a human being deserving of dignity and hope. The issue is how to translate this basic reminder into concrete steps to improve and reform prison practices. Our distinguished witnesses this afternoon engage and lead prison reform efforts around the world. So I look forward to hearing from them about the challenges they face as well as the progress that is being made. Are there countries where conditions are improving? Are there best practices to share? Perhaps you can comment on a debate that we continue to have in the United States, the differences between privately run prisons and prisons run by the government. And most important for us, what more can the United States Congress do to end human rights abuses against prisoners around the world and ensure that they are treated with dignity? So I'm grateful that you are here, and if I'm not here physically, I will be here in spirit, and there are people in the audience here who will inform me of what you say. But again, thank you for your work. I yield back.
Thank you. I do appreciate, sorry about that, I do appreciate Co-Chairman McGovern, and I do give him great kudos for serving on the Rules Committee. That is really challenging.
Like a pay increase.
I know. It's like combat pay, I think, some days. Some really late nights, but appreciate his commitment to be here, and absolutely understand his demands on his time at the Rules Committee. But so grateful for our panelists. We'll have 2 panels today, and I'm going to recognize them now for their testimony, and then we'll have some questions, if that's all right. So first, mentioned Philippe Meissner, Crime Prevention and Criminal Justice Office, United Nations Office on Drugs and Crime. And then also Hillary Anderson, Senior Specialist, Inter-American Commission of Women, Organization of American States. So grateful you're here. Philip, first we'll recognize you. Thank you.
Good afternoon. Thank you very much, Representative Hultgren and Representative McGovern, for convening this important meeting today and for inviting UNODC to testify before this commission. It's a great pleasure to be here. Let me start my testimony pretty much along your lines by reiterating the importance and urgency of addressing prison management from an international perspective. As not only are we talking, as Representative McGovern has already mentioned, about a very significant and growing population, currently standing at more than 10 million prisoners worldwide, 2.5 million of whom on remand. But we're also talking about massive challenges, really, to ensure they're safe, they're secure, and their humane custody. The global phenomenon of prison overcrowding, which is probably one of the most visible of these challenges, continues to affect a solid majority of member states worldwide. In its most extreme forms, this results in life-threatening situations in which the health, the safety, and really the most basic needs of prisoners may be neglected, in which prisoners may literally have to sleep in shifts due to a lack of space, and in which the key principle of a proactive rehabilitation of offenders is in practice being reduced to their temporary incapacitation at best. Too often, however, situations such as these go unnoticed for too long, despite the fact that it is, as we all know, not only the human rights of prisoners that are at stake, but also public safety and public health. This being said, as you have mentioned, there is also reason for hope, as prison reform efforts have gained a significant renewed momentum following a landmark achievement at international level in December 2005, namely the adoption of the revised standard minimum rules for the treatment of prisoners, the so-called Nelson Mandela rules. And despite their legally non-binding nature, these 122 rules, and I brought hopefully a sufficient number of copies with me for your kind considerations, represent the single most important normative compass for prison management that has been universally endorsed by the international community. The overall parameters of these rules being that prisoners must be treated in line with their dignity and value as human beings, and importantly, that the ultimate purpose of imprisonment, namely the protection of society from crime, can only be achieved if the period of imprisonment is used as much as possible to prepare prisoners for their successful reintegration into society upon release. Now, as you may recall, the Nelson Mandela rules are the result of an intense intergovernmental effort to update the original version, the standard minimum rules from 1955. And in light of the vast diversity of prison systems worldwide, you can imagine the formidable challenge of member states from across the globe convening in order to agree by consensus on enhanced global standards for prison management. Unsurprisingly, therefore, it took 4 intergovernmental expert group meetings between 2012 and 2015 to agree on a revised wording and content of the rules. With your permission, allow me please to briefly mention 5 thematic areas which were given particularly attention during the revision process. First of all, principles related to the humane treatment of prisoners have been strengthened, including obviously the absolute prohibition of torture or ill treatment. These are secondly complemented by numerous procedural safeguards for prisoners, such as those related to requests and complaints, to prisoners' access to legal advice, and importantly, the requirement for regular inspections of prisons, both of an internal and of an external independent nature. Thirdly, the Nelson Mandela rules set forward detailed guidance on restrictions and discipline, including disciplinary sanctions, be it guidance on searches of prisoners or cells, be it guidance on the use of instruments of restraint, or be it the strict limitations applicable to the use of solitary confinement. On this particular point, and due to its potentially severe consequences on prisoners, the Nelson Mandela rules now prohibit solitary confinement beyond a duration of 15 consecutive days. They prohibit the imposition of solitary confinement by virtue of a prisoner's sentence, or its use on specific categories of prisoners which are considered particularly vulnerable. Another extensive and fourth area of revision relates to the provision and quality of healthcare services in prisons, including respective duties and prohibitions of healthcare professionals. Finally, a point that I personally feel also strongly about in light of the challenging duties of prison staff, the need for tailored and extensive training of prison officials, be it induction training or in-service training, is now equally firmly anchored in the revised rules. Distinguished co-chairs, there is no doubt that the adoption of the Nelson Mandela rules in and by itself is a reason to celebrate. It is our hope, however, that the significant resources that went into the revision process will now be matched by similar efforts to support the practical application of the rules worldwide. As a guardian of the Nelson Mandela rules and other relevant standards, such as Bangkok rules with regards to the treatment of women prisoners, UNODC has been requested by the General Assembly to provide further guidance material on the rules and to deliver technical assistance to member states. And building on our past work in the field of prison reform, we have therefore launched the first ever dedicated global program of UNODC on addressing prison challenges. Keeping in mind that obviously a lot of the challenges that manifest in prisons, including overcrowding, for example, go very well beyond the control of the prison administration, but rather are a result of overall deficiencies in the criminal justice system. UNODC's program therefore focuses on three strategic objectives, namely to assist member states upon request in rationalizing the scope of imprisonment, including by means of an increased resort to non-custodial sanctions. Second, the core of the program, strengthening prison management and improving prison conditions. And third, supporting the social reintegration of prisoners upon release. Beyond UNODC, we also feel very much encouraged by the fact that the renewed spotlight on prison conditions and the treatment of prisoners, which the Nelson Mandela rules have certainly created, also manifested in May last year in the formation of a Vienna-based group of friends of the Nelson Mandela rules, which is an informal group of like-minded member states which have a particular interest in supporting the practical application of the rules, together with UNODC, other international and regional organizations, as well as civil society. I would like to conclude, Mr. Co-Chair, by calling upon all of us to make use of this updated and universally accepted blueprint for prison management for the benefit of an often forgotten population, for the benefit of their families and children, for the benefit of public officials working in prisons who very often do not receive the recognition that they deserve, and finally for the benefits of society as at large, to whom we must not forget the vast majority of prisoners will eventually return. I thank you very much for your attention and look forward to your questions. Thank you.
Thank you, Mr. Meisner. I'll fix my microphone here and recognize Ms. Anderson. Thank you very much.
Thank you very much, Mr. Co-Chair. Good afternoon, everybody. While women deprived of liberty in the Americas still represent just under 5% of the total prison population, so not a big number, they face a series of differentiated risks and obstacles that relate to the historic social and economic inequality between women and men that systematically place them at a disadvantage in a variety of ways. As an important first point before I go on, the data on women deprived of liberty in the region of the Americas is not strong. That said, we do have a general profile of incarcerated women. Globally, according to the Institute for Criminal Policy Research, since 2000, the incarceration of women has grown by 51.6%, and that's faster than any region in the world except Asia, and much faster than the rate of incarceration of men. And this is mainly a result of increasingly harsh policies related to drugs. In the Americas, between 60 to 80% of women in prisons are incarcerated for drug-related crimes. And a large number of these women, as Representative McGovern alluded to earlier, are actually in pretrial detention rather than prison. These tend to be low-level, non-violent offenses related to micro-trafficking, small-scale sales, trying to bring drugs into penitentiary centers, transporting money, and other similar acts. Incarcerated women are mainly poor, less educated, living in precarious economic and social circumstances. These circumstances often force them, either through economic necessity, some type of coercion from male family or community members, or a combination of the two things, to participate in these low-level offenses. Incarcerated women are frequently single mothers with sole or primary responsibility for the maintenance of their households and their families. Their incarceration thus affects not only them, but the children and other persons for whom they're responsible, which may include elderly, ill, and/or disabled family members. When a woman is incarcerated, there are limited options for her children and other dependent family members. Children are either placed in prison with their mothers, generally up to the age of about 5 years old in the Americas, although it varies from country to country, in the care of another, usually female family member, such as a grandmother, an aunt, or an older daughter, or they're institutionalized by the state. While it's clear that the incarceration of a father has, unfortunately, less impact on children than the incarceration of their mother, we don't have a lot of concrete information on what happens to children psychologically, socially, and economically when their parents, in particular their mothers, are incarcerated. A recent study by the Church World Service and Gurises Unidos in Uruguay points to the multiple human rights that are placed at risk when a child's parent or parents are incarcerated, including the fact that the lack of documentation of their vulnerability and the lack of coordination between state judicial, penitentiary, and child protection systems. The incarceration of women leaves the people under their care vulnerable to poverty, marginalization, and neglect, which can in turn have long-term consequences, such as their own involvement in criminal organizations and even institutionalization. A lot of the evidence that we currently have on the violations of the human rights of incarcerated women is anecdotal. And that's not to minimize its importance, because there is a lot of anecdotal evidence, but it is to call attention to the need for a more rigorous and systematic approach to identifying, documenting, and above all, responding to these violations of human rights. A recent study from the Inter-American Commission on Human Rights at the OAS on the use of pretrial detention in the Americas points to the disproportionately serious hardships and adverse consequences that affect women who are deprived of liberty, including a lack of female-only detention centers. They're often placed in detention centers with male prisoners. An inadequate prison infrastructure, bearing in mind their gender and the development of their mother-child relationships and their particular needs in terms of access to health care. A lack of gender-appropriate medical treatment, greater difficulties with social reintegration, an absence of a gender perspective in data gathering on the deprivation of liberty, and subjection to forms of violence, including sexual abuse by prison staff. This situation is exacerbated by the fact that incarcerated women have even less access to recourse than women in the general population when their rights are violated, subjected as they are to the complete control and power of state agents. This is particularly worrying in cases of physical and sexual violence against female inmates, which are common but occur with almost complete impunity. A recent report from Equis Justicia in Mexico presents the results of a series of interviews with women inmates that highlight some of the violations to which they're subjected. And these include, but are not limited to, physical violence such as near asphyxiation with plastic bags, beatings and other forms of physical torture which may result in incapacitation and often miscarriage, forced nudity such as being observed while in the shower or using the toilet, and invasive body searches by male prison guards, other forms of sexual torture and rape, including penetration with both penises and other foreign objects, of women throughout arrest, pretrial detention, trial, sentencing, and incarceration, most often at the hands of prison guards and other agents of the state. Forced prostitution, or exchange of sex for favors, quote unquote, which can include simply an absence of physical and sexual violence, or things like increased access to contact with family members, or material benefits such as improved accommodations. Lack of access to or denial of healthcare services, or specific violations committed during the provision of healthcare services, including the shackling of pregnant women to their beds during labor and delivery. Lack of access to contraceptives and HIV prevention tools despite the presence of sexual violence against female inmates, or their inability to negotiate sex with their partners during conjugal visits. Forced nudity and invasive body searches by male prison guards of women who visit male partners or other male or female relatives and friends in penitentiary centers. So this is not a problem that specifically affects incarcerated women, but it does affect women who have to visit prisons. As we've seen globally in recent months, violence against women in general is underreported. These violations committed against female inmates are even more significantly underreported, as they're often committed by the very people responsible for taking these reports and guaranteeing the health and safety of female inmates. While the physical consequences of this violence, including injuries, forced miscarriages, and forced pregnancy, among others, often go undocumented and unattended, it's the psychological trauma and stigma attached to sexual violence that the women interviewed in Mexico reference most frequently. This trauma and shame often leads to their own self-isolation and withdrawal from contact with their families, as well as to a general lack of confidence in institutions of the state. A number of countries in the region have taken concrete steps to address the situation of incarcerated women. And in addition to the limited but growing body of international law that explicitly or implicitly protects the rights of people deprived of liberty, in this context, there are several tools at the international and inter-American level that can assist states in strengthening the gender perspective of their prison reform efforts. These tools include, in the Americas region, the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, known as the Belém-do Pará Convention, which establishes violence against women as a violation of their human rights, including when it is perpetrated or tolerated by the state or its agents, and creates a state obligation of due diligence for the investigation, punishment, and reparation of crimes of violence against women. The United Nations rules for the treatment of women prisoners and non-custodial measures for women offenders, usually known as the Bangkok Rules, which all of my colleagues have referenced previously, which give guidance to policymakers, legislators, sentencing authorities, and prison staff in order to reduce the imprisonment of women and to meet the specific needs of incarcerated women. The Bangkok Rules address admission procedures, access to health care, which is broadly understood to include treatment for substance abuse, psychological care to prevent suicide and self-harm, and preventive health care, humane treatment, search procedures, and children who accompany their mothers into penitentiary centers. The decision of the Inter-American Court of Human Rights in the case of the Miguel Castro Prison v. Peru, which among other standards established that the use of physical violence and sexual abuse by agents of the state, in this case the Peruvian National Police and the Peruvian military, as well as the denial of health services to pregnant inmates, constituted both violence against women under the Belém-do Pará Convention and torture under the terms of the Inter-American Convention to Prevent and Punish Torture. Resolution 2907 of the OAS General Assembly, it's from 2017, which among other things requested the OAS General Secretariat to examine the implementation of alternatives to incarceration, special treatment initiatives, and evidence-based social reintegration programs, bearing in mind the increasing number of women in the region who've been deprived of their liberty for drug use or minor drug trafficking offenses, and the enormous family, social, economic, and institutional repercussions that this entails. This resolution joins a series of previous resolutions that address issues of drug policy and incarceration from various perspectives, with a specific focus on human rights and, to an increasing degree, gender equality. Even in the context of the limited body of data on the situation of incarcerated women, a number of concrete policy and programmatic recommendations are still possible. For example, adopting a gender perspective in the design, implementation, and follow-up of legislative and policy reforms on the issue of penal reform. Considering the use of alternative sentencing, non-custodial measures such as house arrest, and other measures for women accused of low-level, nonviolent offenses, taking particular note of the potential impact of incarceration on women's dependent family members, including children, people with disabilities, and older persons. Establishing procedures and mechanisms to monitor the implementation of follow-up of these measures is another crucial component. Prioritizing the implementation of economic and social reintegration programs for incarcerated women that will, on the one hand, minimize the impact of incarceration on their families and the persons under their care, and on the other hand, provide them with concrete tools to build their own economic autonomy on leaving prison, thus reducing the risk of recidivism. Employing an intersectional and intercultural approach to prison reform that takes into account the additional risks and obstacles faced by Afro-descendant persons, Indigenous persons, LGBTI and older persons, people with disabilities, and children and adolescents. These risks include additional or aggravated violations of human rights. In particular, as the Inter-American Commission of Human Rights has pointed out, the needs of trans persons should be taken into account, and these persons should be consulted in deciding whether to place them in penitentiary centers designed for a population whose gender is not that with which the trans person identifies. For example, trans women housed in prison for the male population, or vice versa. Thank you.
Thank you both for your testimony. If I can have a few questions for each of you, if that's all right, before we move on to our second panel. Mr. Meissner, what priorities does UNODC typically consider when developing technical assistance projects to advance prison reform? And then just wondering about how do you ensure, or even how do you get buy-in from prison administration or prison staff to carry this out?
Thank you very much, Mr. Co-Chair, for this very pertinent question. In the context of our technical assistance programs, we typically start our engagement, obviously, with an assessment of the respective prison system in order to identify jointly with the respective prison administrations the bottlenecks and priority reforms that are needed, coupled with a sort of strategic planning exercise where we lay out a sequence steps, a sequence set of subsequent set of steps for reform. In terms of thematic areas that we consider, we obviously look first of all at relevant legislation, be it primary legislation, the National Prison Law, Prison Act, as well as secondary legislation, the type of prison regulations and standing orders that provide more detailed guidance for prison officers and refine these together with the national counterparts. We look at safety and security in prisons, including the classification procedures that are in place to separate different categories of prisoners according to the risk that they may pose, but also according to the special needs that they may have. The other side of the coin, prison-based rehabilitation, is a priority area for us. We are engaged in many countries trying to initiate and enhance prison-based rehabilitation programs ranging from education to vocational training to work programs. Healthcare services, also a priority. Very often healthcare services are very poor and the state of the prison clinics is very poor, so we try to assist in refurbishing and enhancing the capacity of health clinics and providing tailored training for healthcare professionals. Since you were asking about how to get the buy-in from prison staff, capacity building for prison staff is a core element of any of our technical assistance activities, and we do not get tired of saying that despite all the constraints that you may face in terms of infrastructure, in terms of financial allocations, etc., when it comes to it, your most important element is your prison staff, the most important element in any prison system. So we provide a lot of training on different aspects of prison management to prison officials, including training of trainers to render this sustainable. Ideally also coupled with a lot of support for prison staff training academies. Prison staff training in reality often still consists of a very much of a law enforcement based training, very close to the training of police officers. We keep on saying prison officers need to have a distinct mentality. Their work is very different from other law enforcement officers. So that's why this focus on prison staff training. Finally, one area that I equally consider very important is that we observe that in many cases prison administrations are left alone with their task of providing for safety, security and rehabilitation in prisons. And the point that we continuously make is that other governmental entities also have a very important role to play in fostering the rehabilitation of offenders in particular. So we very often try to convene meetings on a broader scale, inviting representatives from the Ministry of Health, Ministry of Labor, Ministry of Education. All of them have a role to play in supporting the prison administration in doing their job. So this in a nutshell would be the sort of main areas that we look at when we deal with prison reform technical assistance projects.
Let me follow up on a couple things, if that's all right, that you mentioned there. One is you talked a little bit about certain prison populations that might have particular vulnerabilities or challenges. How do you identify them, and how do you work with, again, those prison leaders to recognize that and make adjustments? Are they willing to do that, I guess? And then also following up on the healthcare demands, how's that going? Again, I'm sure it would take some outside resources or entities where a lot of these prisons aren't set up to also be healthcare providers. So wondering how that is going and if there is a willingness from outside medical providers to be a part of some of the health reform that's necessary if you're going to truly have prison reform.
Thank you very much. I'll start with your first question related to categories of prisoners with special needs, and I'm very grateful that you're asking this question, because in the public discourse very often prisoners are represented as a sort of homogeneous group, a uniform block of prisoners, and this could not be further away from reality. As I mentioned in my introductory statement, prisoners are a very diverse population, both in terms of the risks that they may pose, but also in terms of the specific needs that they may have and the different way they will react to imprisonment. And I just want to outline a couple of special categories in this regard. First of all, we are talking about specific needs related to age. Juveniles, obviously younger prisoners that are exposed to certain risks in prisons and that will have special needs. But we are also, and that is often not mentioned, increasingly talking about the challenges that older prisoners face, in particular in view of long-term sentences. So this is also a group that needs to be taken into account. We are talking about specific categories due to gender. The gender-specific needs of women prisoners have already been mentioned. We are talking about specific needs resulting from disabilities. Prisoners with either mental or physical disabilities, and how prison administrations can ensure that they have a possibility to be involved in the prison regime. We are also talking about specific needs related to origin and background. In a large number of jurisdictions, foreign prisoners represent a very high share of the prison population. In others, it is members of ethnic minorities that are disproportionately represented in prisons. So here we face issues around language, about cultural practices, about continued contacts with the families, consulates, etc. And finally, another group I would like to highlight is prisoners that undergo a specific form of a sentence, for example, long-term prisoners or prisoners sentenced for life. So here we have issues around institutionalization. How do you keep up the hope of those prisoners? Unfortunately, we face here sometimes situations where this group in particular is being deprived of any possibility to continue to benefit from rehabilitation or social reintegration efforts. So it's there is certainly a need to raise awareness amongst prison officials about these groups of prisoners that have specific needs. We also work very closely with prison administrations for them to be able to assess the profile of their prison population more clearly. Upon admission, information needs to be collected about each prisoner in order to be able to say, well, we have this number of prisoners belonging to a certain category and we need to take care of them. According to my experience, it's not necessarily the case that prison officers do not want to cater for the specific needs of prisoners. Very often they do not have the possibility to do so because they lack time, they lack equipment, they lack infrastructure. So with the support and in the context of the technical assistance programs that we deliver, a lot of change is possible through a solid cooperation in that regard.
Thank you. Ms. Anderson, I wonder if I could ask a couple questions to you. One of the greatest heartbreaks that I continue to face is human trafficking, and wondered if you could maybe talk a little bit about the intersection of trafficking in persons and international prison reform as it relates to women. I know many countries are still placing trafficked women into prison, even though such women are themselves victims of crime. How can prison reform be linked to improvements in rehabilitation and bringing back hope again for trafficking victims?
I'll pick up on Philip's point on the necessity of disaggregating the prison population and taking into account the differences between them. And I think that holds true for victims of trafficking as well. There's a need to identify these women and the specific risks that they face on the one hand and the specific needs that they might have on the other hand, including access to interpretation in whatever their local language might be if they happen to find themselves in prison in the country to which they were trafficked as opposed to their country of origin, specific healthcare needs that they may have as a result of being trafficked for sexual exploitation or even forced labor, needs that they may have in terms of support for migration processes if they're intending to stay in their destination country, or if they're being transported back to their country of origin. There's always a need for legal services in that regard. And then I think the main need is for social economic reintegration programs to ensure that they have something, when they're released from prison, that they have something to fall back on, so that they don't end up either falling victim unwittingly to traffickers or knowingly getting involved with trafficking networks, because it is both situations, but it's mostly a result of economic necessity. So I think, that the whole series of programs is important, and it's important that we know that we understand the profile of women who are victims of trafficking, who also find themselves in prison.
I wonder if I could get your opinion on the World Prison Brief showed an increase of 50% in the number of women incarcerated since 2000. So the rate of increase that's more than double that of experienced by men in the same period. How can you explain this discrepancy, and is there more to it that we ought to be aware of?
It's mainly a result, I think, of increasingly harsh policies related to drugs. As policies on the issue of drugs have grown more and more harsh, more and more women have been imprisoned for, as I said, sort of low-level, nonviolent crimes related to micro-trafficking, to small-scale sales and things. That's, I would say, the main factor responsible for the increase in incarceration of women over the last 20 years or so. We've done quite a bit of work from the Organization of American States in collaboration with the Washington Office on Latin America and other organizations on precisely that, on policy reform related to women and women drug policy and incarceration, and looking at things like alternative sentencing, house arrest, I can't remember the name in English, libertad condicional. Anyway, that's it. Yeah, conditional release. Thank you. And other measures that may be applied to these women who become involved in drug-related crimes, mainly out of economic necessity and a need to provide for their families, their children, other dependent family members, and who are generally not high up in the chain in terms of the drugs industry. They're not the queen of the South or anything like that. They're low-level mules who they're not the main beneficiaries of the drugs trade, and they would benefit far more from, again, social and economic reintegration programs that gave them a real possibility of providing for their families in the future than just prison sentence after prison sentence.
Following up on that a little bit, in my district, I know almost every other district, drug courts have become an important part of our judicial system. Are you seeing that approach accepted in other places around the world as well? What can we do, I guess, to encourage that, of recognizing, and then, I guess, making sure that treatment is happening as well, where sometimes that's the greater need for these people, is to get the treatment and care that they need.
Yeah. I should point out that the majority of women are not imprisoned for crimes related to addiction. It does happen, but the majority of women are not necessarily struggling with addiction problems. They're there more for micro-trafficking and other related crimes. The drug courts model has certainly been pushed to other countries and is being replicated in a number of countries throughout the Americas. To the extent that it judicializes what is essentially a healthcare problem, it has some human rights implications that are being explored at the OAS at the moment. To the extent that it does give people who are struggling with addiction a real possibility at healthcare treatment, it seems there are positive aspects to it as well. It's not as relevant to the situation of women incarcerated for drug-related crimes as it may be for men, just because it's not the majority of the population.
Okay, thank you. If I can wrap up with one last question for each of you, and then we'll switch to our second panel. But this is challenging work that you're involved in, and just wonder how if there is one thing that gives you hope, maybe a situation or an example of something where you're seeing some real progress that you can get excited about, that kind of gives you the energy to keep moving forward. And then also, if there is a thought or two that you have, I see part of my responsibility, my co-chairman shares this, that we want to get information to share with the rest of our colleagues of the impact that we can have as members of Congress to encourage right reform. So just wonder briefly if you could talk about what can we do as Congress to encourage right reform. So maybe we'll start, Ms. Anderson, if you'd start, and then Mr. Meissner, if you'd finish up.
We have seen a number of positive examples throughout the region in terms of just recognizing the differential effect on women of incarceration, and trying to develop targeted policies to address their specific needs. So a significant number of countries in the region have at least started paying attention to the issue, which is an important first step, and making policies in that regard. As Congress people, I would recommend, first and foremost, pushing for better data, sex disaggregated data, and data that's disaggregated by other factors like ethnicity, country of origin, and things like that, people with disabilities, etc. And then I would say really keeping the focus on rehabilitation, certainly in the case of women, because I think these are the people that would benefit most from rehabilitation efforts, are the people that are in prison because they fell into something out of economic necessity, rather than any of the other reasons people may get involved in more violent crimes. So keeping sort of at the center of prison reform efforts the possibility, the hope of reintegration of some of these inmates.
Thank you, and my apologies, Representative. I missed to answer a second element of your question, which you asked me previously, which was related to healthcare. So please allow me just to add one more sentence on your question about penitentiary healthcare and the challenges that many prison administrations face in this regard. I'll be very brief. I just want to make the point that in many prison systems, obviously, the responsibility for healthcare remains with either the Ministry of Justice or the Ministry of Interior, depending on who is in charge of the overall prison administration. And this in itself sometimes poses problems in terms of ensuring what we call equivalence of care, meaning that prisoners should have access to the same type of quality services that persons outside have access to, due to the fact that the penitentiary healthcare system is insufficiently linked to the public healthcare system outside. This then cascades into a lot of other questions around personnel, which kind of doctor, nurse, physician, or psychologist wants to work in a prison. What are the conditions of healthcare work in prisons? How is it paid, etc. So I think it's important to recall this very issue about the linkage of penitentiary healthcare to the public healthcare system outside. You asked about what is encouraging us in our work. I need to come back to the Nelson Mandela rules. It certainly has created tremendous momentum, which we can observe in many member states, a lot of interest to follow up, to assess their compliance, to improve their compliance. So the number of technical assistance requests we receive and the openness of member states to work with us and other partners on improving their compliance with Nelson Mandela rules has definitely increased. I also want to make a point. We don't have a Prisoner Rights Day at international level yet, but we do have now 18th of July, which is Nelson Mandela International Day. And you may recall that when the Nelson Mandela rules were adopted, the General Assembly also made a decision to extend the scope of Nelson Mandela International Day, which is now also to be utilized in order to promote humane conditions of imprisonment, to make a point that prisoners continue to be part of society, and to value the work of prison staff as a social service of great importance. And I think when you were asking us about what you can do, I think this is a crucial point, not only on 18th of July, but throughout the year, to raise awareness in society about the very point of the Nelson Mandela rules, which I have mentioned, that it is also in the interest of society to foster the rehabilitation of prisoners. In a lot of countries where we work, one issue is certainly that society at large is not taken along when it comes to prison reform efforts, and especially in low-resource environments where the resources are scarce to start with. We hear a lot, but we didn't commit any crime. Why are you now asking us to invest in prisons? So this explanation that it's not only about giving resources to prisoners, it's also about public safety and public health. This is a point that we would very much appreciate if it could come from the policy side as well, more strongly. Thank you.
Again, thank you so much. We'll make a switch with our panels now, but really appreciate your testimony. Thank you. Welcome to our second panel. We are grateful for your involvement as well. I've got two great panelists on our second panel also. Craig DeRoche is a friend and someone I'm grateful for your work and passion for these issues. Craig is Senior Vice President for Advocacy and Public Policy for Prison Fellowship. We're also really honored to be joined by video long distance away. Azamat Shambalov, Regional Director, Office for Central Asia Penal Reform International, and he's joining us from Kyrgyzstan live via video, so thank you so much for being here as well. I'm going to recognize Craig first for his testimony, and then we'll hear from Azamat, if that's all right, and then I'll have some questions for each of you. So, Craig, if you could start with your testimony.
Thank you, Mr. Chairman. It's an honor and a privilege to be here, and thank you for that very heartfelt comments about prison fellowship. And I want you to know, Mr. Chairman, that Emily Colson was intending on being here today, but she had to get back to Boston, and she was in town for a Colson Center board meeting, and she sends to you and the entire commission her best.
Thanks, and if you would, please send my best to the Colson family. Let them know I continue to think about them, so thank you.
Yep, thank you. Prison Fellowship was born out of the experience of the late Charles Colson, aide to former President Richard Nixon, who was convicted of a felony and a Watergate-related offense. While he was incarcerated for 7 months, he saw the experience and difference that his faith in Jesus could make in people's lives, and he felt that a real solution in spiritual growth and development could be a solution to crime. So when he entered freedom after his prison stay, he endeavored to reach out to men and women behind bars with an opportunity for themselves to transform their lives, and he founded Prison Fellowship in 1976. Today, Prison Fellowship is the largest Christian ministry outreach to prisoners, former prisoners, and their families in America, with 365,000 prisoners that will serve in one capacity or another this year. 11,200 volunteers help us do that in our staffed and volunteer academies, which we have 77 of in 28 states. Just last month, we had our Angel Tree program, where it's Christmas for the prisoners, facilitated by volunteers through the local church and Prison Fellowship. We did over 250,000 of those. And it's estimated that more than 150,000 volunteers participate during just the month of December in that process. So it's just a real blessing to be here and really to testify before this commission and distinguished guests in conjunction with Prison Fellowship International, which was founded in 1979, to extend the mission and work beyond the United States and to bring God's goodwill of alleviating the suffering of prisoners and their families worldwide. And in 1983, Prison Fellowship International received a special consultative status with the Economic and Social Council of the United Nations. Today, Prison Fellowship International is the largest and most extensive association of national Christian ministries working within the criminal justice field in the world. And each of the trans-denominational national ministries is grounded with indigenous leadership and local funding. This grassroots presence enables Prison Fellowship International to minister to prisoners and their families in culturally relevant ways. Much has been said, Mr. Chairman, about the Nelson Mandela rules and the status of international prison conditions, and due to the constraints of the time that I have, I'll skip through this, but to acknowledge that in our testimony, the written testimony we've submitted, we talk about the growth of women in prisons with the same citations and concerns. We talk about the number of individuals in prison, and we draw for the Commission's benefit the European countries such as Norway, Denmark, and Germany that are often highlighted as standout examples of prison systems that are more closely resemble an individual's home than a prison, and the results that come from that, and really deliberately inserted that because I've toured the German prisons. I'll talk a little bit more about that in our recommendations, but as a pathway to go towards a solution. for crime. In America, our federal system is currently exceeding capacity by 114%. While most states have a prison population slightly below their occupational capacity, Illinois has one of the worst. Around the country, though, around the world, it is much worse. Haiti has a prison population that exceeds its official prison capacity by 455%. El Salvador exceeds it by 348%. The overcrowding is not restricted to the Western Hemisphere, with the Philippines, Chad, and Grenada also facing extreme overcrowding in their prisons of 436%, 232%, and 235%, respectively. Overcrowding can result in increased illness, death, suicide, and may drive violence. For example, in the central prison in Romaik, Lebanon, faced a violent riot after operating at almost double capacity. In 2013, Prison Fellowship International did a survey of the affiliates around the globe. In 100 of the 125 countries that have Prison Fellowship International affiliates, 79% of them had responded and engaged in activities because of overcrowding and lack of services that affected the health and welfare of the people in where Prison Fellowship International as an NGO had to provide basic human services into the prisons. In addition to the poor conditions of neglect, individuals held in prisons around the world also face deliberate physical, psychological, and sexual mistreatment, as we've heard from some of the other testimony today. Mistreatment is sometimes used as a means of exerting control or punishing individuals who are incarcerated. In North Korea, for example, prisoners are routinely subject to severe beatings, electric shock, and confinement in small, immobile cells. In 2012, the United Nations Assistance Mission in Afghanistan reported that it found evidence that in more than half of 635 detainees interviewed experienced torture or ill treatment. Incidents of mistreatment not only violate human rights, but undermine the credibility of the justice systems in these countries. This being said, Mr. Chairman, I wanted to draw a highlight in my testimony today to some of the promising aspects of that are evolving in prisons around the world. And while the status of prison conditions seem overwhelming, there are things like Prison Fellowship's Zambia work that manages clinics to teach prisoners about issues such as hygiene, nutrition, and HIV. Prison Fellowship Zambia team provides information leaflets translated into a variety of languages in order to overcome the barriers of illiteracy, and dramatic presentations and music are often used. The drama group visits prisons and presents health messages using singing, drums, acting, and picture demonstrations. And Prison Fellowship volunteers multiply their reach by training prisoners as peer educators to run individual and group discussions on subjects like HIV prevention, and many peer educators are HIV positive themselves, and they work to help overcome the stigma of the disease. In addition, Prison Fellowship Zimbabwe worked tirelessly to repeal a law that prohibited children from visiting incarcerated parents before 18 years of age, as something that contributed to the breakdown of families. And maybe most importantly for the testimony today, for a highlighted positive development would be that in the growth of restorative justice around the world, Mr. Chairman. The modern restorative justice movement began about 30 years ago, but it draws from much older forms of justice from the early Middle Eastern and Mediterranean civilizations that shaped Western culture. These approaches to justice are still being used by indigenous peoples around the world. In July 2002, the United Nations Economic and Social Council adopted the basic principles and use of restorative justice programs in criminal matters, and Prison Fellowship was an influential non-NGO in helping develop these principles. And it approaches crime in an entirely different way, including a preventative program that before crimes occur, as well as an alternative to traditional criminal justice sentencing as a mediation process, as well in post-sentencing when desired by the victim. Restorative justice can be everything from apologies, when voluntary and genuine agreement to change future behavior, compensation or restitution involving the person agreeing to pay for at least some of the damage he or she has caused. This can be done with paying money, providing services, returning or replacing property, or any other way in which the parties agree. What we've seen in restorative justice, Mr. Chairman, is that that making amends when you involve the victim and the person that's caused the harm, that very creative ways come to the surface, and they can be very innovative. And to that end, restorative justice has demonstrated that it is more effective than the results of traditional criminal justice processes. Researchers reviewing hundreds of studies that compared restorative justice with traditional criminal justice found the following: that it lowers repeat offending, particularly individuals involved with violent crime and adults. It reduces post-traumatic stress of victims. It costs the government less when used as a diversion from prison. It leaves victims and individuals responsible for the crime more satisfied, and it doubles the number of cases brought to justice because it is much faster. Because of this proven record, more and more countries are relying on restorative justice as a key part in response to their crime. For example, the first country to use restorative justice as a major part of its system is New Zealand, who now for 25 years has handled their youth cases entirely through a restorative justice process. They are now extending that to be an integral part of the adult system. Most restorative justice processes take place outside of prisons, but there are some innovative initiatives now that are taking place in prisons. And Prison Fellowship International's Sycamore Tree Project is active in 34 countries that bring groups of crime victims into prison to meet with groups of unrelated prisoners for 8 weeks. The participants talk about the harm caused by the crime and the meaning and importance of a confession, forgiveness, making amends, and reconciliation. It has worked very well. And the corrections official in charge of an overcrowded prison described the facility as calmer and easier to run in the 4 months since Sycamore Tree had started in just one of the countries where this was deployed. We have our recommendations here, Mr. Chairman, that on improving international prison conditions and criminal justice reforms, that this committee and the Congress should look to incorporate these issues into ongoing discussions with international diplomats and dignitaries, and should look to bolster programs that provide funding to countries who lack the resources to ensure proper conditions. We recommend that at the same time we highlight promising practices and excellent corrections professionals around the globe, offering to come alongside corrections staff who have a vision for promoting humane, safe, and transparent and effective prisons. And one way to achieve this goal, Mr. Chairman, is we would encourage the Congress to encourage international delegations with relevant government and non-government actors, particularly corrections professionals, to tour prisons and other criminal justice entities for the purpose of sharing ideas, challenges, and best practices across jurisdictions. And to take a broader approach to the impact of incarceration, recognizing the ripple effect on the prisoners' children and families, victims, and communities, to help build that infrastructure through time, and to promote the use of restorative justice as an alternative to traditional juvenile criminal justice practices and a method of dispute resolution inside prisons by funding and highlighting more expansive programming, research, and marketing of best practices and outcomes. And Mr. Chairman, for the record, I would like to acknowledge the wonderful support of my dear friend and colleague Dan Van Ness, who founded Prison Fellowship's advocacy outreach called Justice Fellowship with Chuck Colson, who is in the process of retiring from Prison Fellowship International, but contributed largely to this testimony today, and I thank you for the privilege of providing it.
Thank you, Mr. DeRoche. We appreciate your work. Next, grateful to have Mr. Shambalov joining us live via video from Kyrgyzstan. Thank you for joining us. First, you have to tell us what time it is, where you're at, and then we'd love to hear your testimony. Thank you so much for joining us.
Hello, everyone. Greetings from Kyrgyzstan, where it's already 2:30 in the morning. Dear Congress members, participants of this important hearing that has to do with the people, human beings issue, as we discussed today. I would like to highlight a bit about Penal Reform International. PRI was established 30 years ago almost by world-leading human rights activists, lawyers, and some of them were also linked to directly prison, as one of the founding members was imprisoned for 17 years. I would like to talk today about the issues of solitary confinement, children in detention, juvenile justice. It's very hard for me to discuss this issue through Skype or through the new technologies because I see these people every day. I work with them, I see the conditions, I work on rehabilitation, and the prison destroys the life, families. It takes away the happiness, it takes away the childhood, it takes away the parents. As a grassroots organizations, and we have regional offices in many countries, I focus mainly on reintegration, torture prevention, also the issues of solitary confinement, and children who are directly linked to many family issues. Majority of children who have been in prison, sentenced for more than 7 years, they end up in adult prison for another 10 years, which shows the lack of rehabilitation programs in some countries, leads to increasing number of prison population. Excessive use of solitary confinement in prison around the world is becoming an increasing issue. Some form of short isolation from rest of the prison population is used almost everywhere as punishment for breaches of prison discipline or regime. However, many states use solitary confinement more routinely for longer periods of time. States justify the use of solitary confinement in a number of different ways. It may be use of disciplinary punishment for convicted prisoners, to protect so-called vulnerable prisoners, or considered to help prison staff to manage certain individuals. It is used to isolate a detainee during the pretrial stage of investigation, often as part of corrective interrogation, and it can be used to lock away prisoners who have or are perceived to have mental illness. While there is no universally agreed definition of solitary confinement, often also called segregation, isolation, lockdown, or supermax, it is commonly understood to be the physical isolation of individuals who are confined to their cells for 22 to 24 hours a day and allowed only minimal, meaningful interaction with others. Contacts with family or visitors often restricted or denied altogether. Despite the fact that contact with the family is in particular have been shown to be an important factor for successful reintegration. The routine used for solitary confinement has been growing and is becoming increasingly common feature of high security or supermax bigger prisons designed to hold prisoners who are deemed high risk or difficult to control, restricted housing. Usually in many countries in the world, particularly in Central Asia, in some Asian countries, in Africa, solitary confinement has to do with the torture. Another issue is the issues of lifers, who are mainly subject to be isolated, segregated for many days, not only hours. There is a concerning issue in our region, also many other countries in the world where we work, the violent extremist prisoners, so-called radicalized prisoners. Most of them are segregated, isolated, and there is no proper reintegration rehabilitation programs developed, as there is a very limited premises in prison to improve or develop rehabilitation programs on countering violent extremism in prisons. If we speak about children in Africa, many children are held in police stations for longer than 24 hours before being brought to court. Many children don't have age records and cannot establish whether they are underage of criminal responsibility age. Police officers don't always identify themselves to arrested and detained children or specify the reason for the arrest of the child. 1/3 of the children interviewed said they had been tortured or subject to violent and inhumane treatment in one of the researches that our partners conducted. children's families were not always notified of their arrest. Children were not always kept separately from adults, and the conditions were generally poor. This can be applied to also some Asian countries, also Central Asia. Because of their unique vulnerability, children in conflict with the law require higher standards and broader safeguards to be applied to them, particularly at the sentencing stage and the criminal proceedings. Judges and prosecutors must be aware of the specific negative effect of criminal sanctions on child, in particular those involving deprivation of liberty. Prosecutors and judges must primarily consider the best interest of the child when requesting the imposing sanctions on children, and includes making individual analysis of the circumstances of both the offense and the child. Prosecutors and lawyers should always first consider alternative measures to detention, such as care, guidance, and supervision, orders, counseling, probation, foster care, education, vocational training programs to ensure that the child are treated with a full respect. I would like to highlight also the children who are in the closed facilities, non-prison institutions. This can be also the concern in many countries too, as these children are potential prisoners that end up in prison in the future because there is no proper reintegration programs hosted within the non-prison institutions. And this is a very Soviet style in our region. This is the Gulag style that has been used for many countries, where children, for not attending school or not visiting the parents or running away from home, they're put in this closed facility for up to 6 months or 2 years. They're not criminals. They're victims themselves, because they're victim of violence where the stepfather or stepmother has been abusing the child. We're working on closing such institutions and encouraging the government to develop alternatives to imprisonment or some closed facilities, such as specialized closed schools. Thank you very much for your attention. Of course, there are a lot of work we are doing in Africa, in Middle East, on countering violent extremism, prevention of torture, building probation, protecting the child rights. I just wanted to highlight the issues that are universal, and this was my analytical review to the world.
Thank you very much, Mr. Shambalov. Appreciate your work and your willingness to join with us, even though it's so early in the morning there where you're at. Means a lot to us that you're with us. I wonder if I could address my questions to you first, just to follow up on some of your testimony. You talked about the extended pretrial detention that often happens, where many times it's more than 24 hours, especially for juveniles. Wonder if there's some alternatives to this type of pretrial detention, and are you seeing any movement there, or what can we do again to push, especially for juveniles, but for all people, to make sure that there's a speed to this, that they're not held for long periods of time without knowing why they're being held?
Mm-hmm. Thank you very much for your question. I think this is a very important question, because many countries in the world, they don't recognize that the child is a child, no matter what offense the child has committed. And the child's psychology and the perception of the criminal justice proceedings is very different. By the formal criminal proceeding, child can be damaged. And the first important thing what needs to be done is the legislative framework. The countries need to create child-friendly justice system, where the child will not be passing through the formal criminal proceedings or the same interviewing and interrogation system that is applied for adults, where the smaller hours will be used for interviews and only one interview will be used for the whole trial cases.
If I can ask you one more question, if you could talk briefly about how you see corruption affecting the availability of justice and fair treatment of those who are accused. Do you see a significant problem with corruption, and what can we do to fight back against that part of it as well?
Thank you very much. This is exactly the question that we have started working from last year. There are no many organizations working in the regions directly with the prisons or governments, with the ministries to fight against corruption in the system, fight against corruption in law enforcement system. Of course, there is many researches has been done, but there is very little area of research has been done regarding the corruption in prison, regarding corruption in police. But we have figured out in our latest project in Kazakhstan that the prisoners use the small amount of bribe or any kind of corruption that they have just to survive in prison or to have access for to some minimum accessible any kind of services such as visiting the family or any kind of contact with the family, having the access to the food or any reintegration program. And the corruption is one of the big obstacles in reforming the criminal justice system, particularly focusing on prison or any kind of law enforcement premises. In this regard, I think the world should think about the prison where the corruption will take place, is taking place, and the corruption can be directly linked to the ill treatment and torture, where some prisoners will not take money or any kind of means to give as the corruption.
Thank you. If I can address a couple questions to Mr. DeRoche, thank you again for being here. Well, you talked some about restorative justice and wondered if you could talk a little bit more about that, of how that is working. I know some of that restorative justice is outside of the prison, but that which is happening inside the prison, how are you working with staff of prisons to help them recognize the importance and the power of restorative justice? And then wonder if you could just talk a little bit about the larger impact on prison populations when restorative justice is a part of the process.
Absolutely. Thank you, Mr. Chairman. Restorative justice, we use two terms at Prison Fellowship: restorative justice and justice that restores. Justice that restores is advocating for a sentencing policy and a tenure in the criminal justice system that seeks a restorative outcome, with or without the victim participating or not. You know, so the victim can stay absent from that, but the court, the state, is still going to try to seek a restorative outcome in the manner in which a person is sentenced. Restorative justice, the word restorative justice, is actually generally acknowledged around the world and in the United States to be the practice of where the person that has caused the harm, the offender, the different words that we use for that, that's committed the crime, and the person that has been harmed actually remediate the damage. Now, to have a vibrant and successful restorative justice program, one of the first things that you need to take into account is the fact that many victims are not willing to participate for a myriad of reasons. We want to be respectful of that. So Prison Fellowship International's Sycamore Tree Project, which is active in 34 countries, actually goes into the prison for 8 weeks and has people of a similar situation, but maybe not the victim of the crime, talking to the person that committed the crime. So in other words, a victim of a home invasion may talk to other people convicted of home invasion and get the answers that they seek, but not have to confront their person for fear of retribution and all the other things that we want to be respectful to victims for. So that's been a very effective program in those 34 countries because it allows really a couple of very important things to occur. One is when somebody is living with criminogenic thinking and is inclined to and participates in a crime, they usually are not fully understanding the damage and the harm they're causing when they do that. And we find in all of Prison Fellowship's programming, whether that's domestic in the United States or around the world, it's one of the very first and most important things we need is the prisoner to understand that they've hurt other human beings and that this isn't a grudge they have with the state, that sentenced them, where they can harbor resentments or anger toward the state. We want them to become aware of the damage they've caused and internalize that and bring about that human response of understanding. With the victims, they get a great deal of, as we've noted, the studies in the testimony that we submitted, a reduction in post-traumatic stress and other things because they see the humanity in the people that they are confronted with and what they're up against and the decisions they made. Doesn't mean that forgiveness is a requirement, doesn't mean that participation is a requirement, but it seems to help both parties. And the origin of justice itself, we always point out, Mr. Chairman, is between the person causing the harm and the person that's been harmed in the community that's been affected. The government, in its best case, is supposed to be a mediator and not the victim itself. And in America, as well as in other countries, the further you get away from the victims of crime having a role in this and the remediation of it, their restoration, it seems the further away from justice you get. So we think that restorative justice policies and practices, while they are not common in the United States of America, would be of great benefit in this country, as has been seen in New Zealand and other countries that have embraced it. And they do very well to speak to the development of the sentencing policies themselves for the lawmakers, because the voice that gets added and the experience that is often absent is that of the victims that have been restored in the process, rather than the victims that are in that acute sense of anger up front.
Thanks. One last question for you, and then
Yeah.
if I can wrap up with a question to each of you. But I wonder if you could talk briefly, and it's come up, I think, in each of your testimony, of challenges of economics and the economies of these countries being a part of the problems in justice systems and prisons. What other situations or circumstances play a part in that? Because we know we'll continue to work to change economies and encourage economic development, but it can't be an excuse either to push off prison reform. So I wonder if you could just talk a little bit about the importance of attitudes or commitments or other things that play a role in where you've seen turnaround of justice systems that still are going to have some economic struggles.
Yeah, I think it's a matter of priorities, and I think that this commission that you and Representative McGovern chair has an important role, and I know that it's a commission, and our recommendations don't offer any force or brash statements, but our recommendations do talk about engagement, because the United States does provide aid for these countries, and when you look at what I've reported in our testimony with the sub-Saharan countries of Uganda and Kenya, what we're seeing in Colombia right now in the state of Antioquia, just this past week with some pretty dramatic situations, to the riot in Lebanon. These are countries that the United States are involved with, and it would be very helpful if we recognize that these are human lives, and when we're making investments in these countries, and the hope that we have for them with the economic growth, that if we allow human beings to be treated without the value of their humanity, without the value of their dignity, that's beneath the values that this country was founded on and how we operate today. And so I pray and I hope that this commission speaks into the Congress and as we said, into the international diplomacy that you're often called to contribute to say that prisons should be a priority in the conditions. And unfortunately, we're starting with, as you've heard the testimony, with things as simple as the prevention of rape and sexual violence, with things like the water and food and medication to be available. So this is not, we're not talking about cable television and recliners in the lounge here. And I think the United States has done a great deal domestically to improve these situations. The Congress has had an active role in that and continues even this session. And I pray that you speak into this with the international community.
We will do our best to do that. What would be helpful, and I guess the wrap-up question I have for both of you, and Mr. Shambilov, if I could start with you. We do want to be able to share the testimony that we've heard today, but what I've found is compelling with my colleagues, along with constituents that I work with is real stories and real people. I wonder, without sacrificing any confidentiality or putting anybody in danger, if there is a person that pops into the front of your mind that we should be aware of, that you have seen struggle, maybe a little bit about their story, just to put a real face on this, because I think where you do see movement and commitment to follow through on this is when we realize that this could be our brother or sister or son or daughter or niece or nephew or father or mother that's in these situations, and that it changes perspective when we realize that. So is there, just quickly, a story or just quick, brief outline of a person we can think of that comes to mind of why this is worth the fight to see some real change? I'd ask Mr. Shambhala first.
Thank you very much for the question. So as far as I understand, you would like to hear a life story, yeah?
If there's just a person, your testimony was so compelling, but you also talked about just in the last day or two dealing with real people, teenagers, young people who are in very difficult situation. If there's one of those that is in the forefront of your mind, again, without doing anything that would hurt confidentiality for them or put them in a difficult position, but just a connection of a situation that might be helpful for us. If not, you could follow up too and let us know by email or something, just again to be able to explain to our colleagues that this is real, that these are real people who are facing these challenges.
Yes, of course, there are plenty of stories. There are maybe hundreds of stories that we hear every day, and I would like to share a story of a boy and one woman. So, briefly speaking, the boy brought up by a single mother, and the mother got married to one guy. And, during the marriages of the first 2 years, the small typical boy started being abused by the husband of the mother, and there was big confrontation between the boy and the stepfather, and the boy started running away from home, and this is the latest case that we're working at the moment, and we're supporting his rehabilitation through psychological support and social care support. At the moment, he's unfortunately in a specialized closed school, so non-prison institution. But it's the same like a prison. The premises are closed. No one can leave this institution. There is the guard. There is the staff members working. And there is special territory allocated. If the boy wants to leave this premises, it's only the judge's decision. So the nonsense of this case is the mother was complaining to the police that her child is violent. But his violence was that he didn't want to live with the stepfather. They couldn't find the same way of understanding of living. And he was not understood by the mother as well. The sad side of this story is the child is alone. Nor the parent, nor the institution, nor the state is not understanding. So at the moment, the boy is passing through the psychological support program, which is very important for boy to have a self-esteem, a self-understanding, also to believe in his future, because he didn't go to the public school for the past 1 year and a half. He has been run away from the school. So the changes to the laws that we are making at the moment in Kazakhstan particularly, where we want to change the schools or prisons for juveniles, how they're operating, as we think it's time for us to change the Gulag system, which was purely focusing on punishment, not the reintegration. And another case, it comes from another country where my colleagues and I are working. It's a case of a woman who was imprisoned because of her behavior in society. They call it deviant behavior, but I am totally against the word deviant behavior. Because someone cannot be deviant. There is a life, there is a situation in life that led women to this position. This woman divorced from her husband. She has 3 children. She started drinking, she started being sad, that led to depression. She started stealing things from the shop, and she started breaking the window of the shop, that they didn't sell alcohol for her in late hours. When I spoke to this lady, she already had some very post-traumatic issues. And we figured out that she started painting. And we opened together a painting classes. In 3 months' time, she became a winning painter among all prisoners. And afterwards, in 3 months' time, so within 6 months, since we started working with her, she applied for parole. She was successful. She was released from prison. And this proves that reintegration program in prison can encourage the prisoners to change their life. And also for prison staff to understand that someone who is in prison can be released earlier without waiting 10 years imprisonment. This is 2 stories.
Thank you very much. That's very helpful. Thank you. Craig, is there a thought or a person?
Yes, thank you, Mr. Chairman. And I'm drawn to a story in Colombia, in the state of Antioquia, as I pointed out, that is in a state of distress at this hour during this hearing. And in Colombia right now, we have 1,000 prisoners that are in police stations, and they're not able to have them there, they have them there because the prisons have no space to put the people. They're forcing people to live in bathrooms and in corridors, even the prosecutor's office. And the Minister of Justice in Colombia, Jorge Eduardo Londaña, said on Tuesday that it is very critical and the government cannot hide it. The Mrs. Lucia Matat talks of despair, as many other family members in Colombia at this hour. In this case, her nephew, who is incarcerated. He broke the law. Again, we're not talking about people that are being unjustly prosecuted in this hearing. We're talking about the conditions of the justice system they face. But for a small crime, and he has a serious medical condition, and you have people that are sleeping in hallways and in basements, not getting basic food or medical care, and that's happening on Earth today, and it's happening on Earth in some of the other countries that I spoke to, in the sub-Saharan countries. And but like my friend who just testified, there is hope. The example I gave in Zimbabwe, there was a family of somebody that Prison Fellowship International provides services to. In this case, the father is incarcerated. They had a policy where children under the age of 18 were not allowed to visit a parent in prison. The mother, who's out of prison, suffered a debilitating stroke. And so Prison Fellowship International, a number of other organizations, advocated for Zimbabwe to change that rule so these children would be able to visit their father in the prison, while at the same time, as an NGO, provided living assistance for the children, got them placed in government assistance where possible, housing, food, and medical care, while their father, who could provide for them, but he's incarcerated. So we make progress, but Mr. Chairman, we slug it out day by day, and we're thankful for the progress that you and your fellow members are making with the American system. And as we move forward to what Prison Fellowship calls Second Chance Month this year, and the month of April, we pray to gain a bunch of ground this year.
Well, thank you. Thank you to each of our witnesses. Grateful for your work and your time and your testimony. And please stay in touch with us. Let us know suggestions, ideas that you have that we can carry out to other members of Congress here. With that, the Lantos Human Rights Commission adjourns this hearing. Thank you so much.